This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the Marine Rule as it is applied to the rejection of or rescission of an insurance contract. In some states, even if the false statements made in an application for insurance were not warranties, but were merely representations that were misrepresented or concealed, whether innocently or intentionally, grounds would exist for rescission. Fraud need not be proved. This is called the Marine Rule. The Marine Rule imposes on the insured, although no inquiry be made, to disclose every fact material to the risk within the insured's knowledge. In other words, an applicant for marine insurance must state all material facts which are known to him and unknown to the insurer. For example, the Supreme Court of Rhode Island, applying the Marine Rule in Guardian Life versus Alfred E. Tillinghast in 1986, found there was no need to prove fraud, even if pleaded, where a material misrepresentation is sufficient to rescind the policy. The California Insurance Code, in language much more stringent than that of other states, allows rescission solely because of concealment or misrepresentation of material fact, even if unintentional. California, New York, and other states have a legislative provision that permits rescission of an insurance contract where the insured has simply negligently or inadvertently failed to reveal certain facts which, if known to the insurer, would have caused it to refuse to issue the policy in question, even if a question was not asked. Concealment can be proved by circumstantial evidence, such as the testimony of the agent. If the agent told the insured that the insurer was concerned about insuring smokers or people with respiratory problems, it can be argued that the insured knew that it was material that the insurer have this information. Failure to provide this information constitutes concealment. The California Insurance Code defined misrepresentation by stating that, quote, a representation is false when the facts fail to correspond with its assertions or stipulations. This is California Insurance Code Section 358. The courts, when dealing with a request for rescission, conclude that fairness and equity require that the contract be treated as if it never existed. Recognize, however, that California is in a minority. California has codified the Marine Rule that states that a material concealment or misrepresentation, whether innocent or intentional, allows the insurer to rescind. First stated by Lord Mansfield in 1766 in the British House of Lords, in a case called Carter v. Bean, California courts apply the Marine Rule, codified in its insurance code, and they apply it stringently. The specific statutes and case law in the state in which the adjuster practices must therefore be reviewed before a decision is made to rescind a policy, so that with the assistance of an independent insurance coverage lawyer, the adjuster will learn whether or not the Marine Rule is applied, and if not, what must be proved before rescission can be attempted. the acts of the insured before the loss can seriously affect the adjustment and the recommendations of the adjuster to the insurer. It is important because an insurer usually need not rely to its detriment on the insured's misrepresentation before it can compel the forfeiture of a policy. A court held that the intent to defraud was sufficient to render the policy void, even if the insurer did not rely on the misrepresentation to its detriment. This was State Farm versus Graham, a 1989 decision of the Indiana Court of Appeal. The marine rule is truly ancient law. The reasons underlying the rule are expressed in the leading case of Carter versus Beam, where Lord Mansfield in 1766 explained that insurance is a contract upon speculation, and since the special facts upon which the contingent chance is to be computed most commonly lie in the knowledge of the insured only, the underwriter proceeds upon confidence that he does not hold back any known fact affecting the risk, and is deceived if such a fact is concealed, even though its suppression should happen through mistake and without fraudulent intention. While this principle still persists in full vigor in marine insurance, it has been relaxed, at least in the United States, in the case of fire and life policies, because of the practice of insurers to make inspections or ask questions which may reasonably be supposed by the insured to produce whatever information the insurer wants. A court held that they thought the marine rule is exceptional only because in other types of insurance the applicant usually may honestly consider himself discharged from any duty of affirmative disclosure about matters concerning which he has not been interrogated. Where that is not the case, the rule of uberrime fides, utmost good faith, should be enforced. This was a decision called Scarborough versus American Manufacturers, a 1979 ruling of the New York appellate courts. If an insured fails to disclose all material facts, the insurer may void the contract. Moreover, a party's intent to conceal or lack thereof is irrelevant to the uberrime fide analysis. In other words, it is of no moment whether the insured breaches its duty to disclose by virtue of calculated deceit or by innocent mistake. The insured's failure to disclose voids the contract and its coverage. Although silence of an applicant may not be fraudulent, the policy could be rescinded, and the duty of utmost good faith must be applied to protect the insurer against being deceived, even if it did not ask the insured the questions that were later found to be material. In Scarborough versus American Manufacturers, a 1997 decision of a New York appellate court, the court found that, quote, in the case at bar, however, plaintiff's non-disclosure was contrived, calculated, and persistent over a 5-month period, wholly apart from plaintiff's failure to disclose the information it had acquired at the time and at the end of this period with respect to deterioration of the risks sought to be insured. was plaintiff's careful concealment of all facts pertaining to the magnitude, identity, and character of that risk. Plaintiff was under a clear affirmative duty to disclose the latter regardless of the standard to be applied. There is no contention that plaintiff met that duty, but on the contrary, actively evaded it." Close quote. To apply the marine rule, the adjuster and the insurer and the insurer's lawyer must understand that because facts about prior claims and cancellations are so frequently misrepresented or concealed, when the adjuster first meets the insured, each of the questions commonly asked on an application for insurance should be asked by the adjuster in order to verify the truth of the representations. If the insured stated on the application that he or she had never had a loss, and then tells the adjuster about 3 prior losses, this could be evidence that there will be a basis for rescission. Similarly, if the insured stated on the application he or she had never had a loss, and an inquiry to the National Insurance Crime Bureau or to the All Claims database proved that, in fact, in the last 3 years they had had 5 prior losses, that will be a basis for rescission. The prudent adjuster should always review the underwriting file or the underwriting materials available on the insurer's intranet. The file should contain the application, the results of the investigation conducted by the underwriter, engineering reports, reports of pre-risk inspectors, notes and inquiries made to the insured by the underwriter that may not have been asked in the application, rating information, calculations of premium, a copy of the declarations page, and partial copies of the policy wording. The adjuster can then determine whether any false representations were made or material facts were concealed. There are many other facts that are important to an underwriter which vary depending on the type of insurance that is being written and the particular underwriter. If the adjuster has any question about materiality, he or she should confer with the underwriter before making recommendations with regard to a claim, especially if one of those recommendations is a consideration of the equitable remedy of rescission. The test of materiality is in most states a subjective test. To determine the materiality of a misrepresentation or a concealment, the adjuster must contact the particular underwriter who made the decision to insure or not insure the particular risk. The adjuster must present true facts to the underwriter and find out what effect the true facts would have had on the decision to insure or not insure. The materiality requirement is satisfied if the false statement concerns a subject relevant and germane to the insurer's investigation as it was thus and then proceeding before a decision was made to accept the risk and write an insurance policy. When questioning an underwriter, the insurer's counsel or adjuster must avoid asking leading questions. An underwriter may unconsciously be led to do or say what the underwriter perceives the adjuster or counsel wants to hear. The adjuster should interview the underwriter with caution, without bias, and with a desire to only learn the true intent of the underwriter. If the true facts would have had no effect on the underwriter, there is no ground for rescission. If, on the other hand, the underwriter advises that he would not have written the risk at all, would only have considered the risk at a higher premium, or would have accepted the risk if the physical protection of the property was greater. In such situations, grounds exist to allow for rescission of a policy of insurance. Any one of the conclusions standing alone is sufficient to establish that a misrepresentation was material to the decision of the underwriter to insure or not insure. Different courts have characterized the element of materiality differently, where one might say a fact is material when it would so increase the degree or character of the risk of the insurance so as to substantially influence its issuance or substantially affect the rate of premium. In Connecticut, for example, it is necessary to show that the premium would be substantially increased or the insurer would have probably refused to take the risk. A test for determining whether a misstatement in an insurance application is material. A misrepresentation is material if it is such that the insurer would not have entered into the contract had it known the true facts, or would have entered into a different contract had it known the true facts. This video was adapted from my book Zelma on Insurance Claims, Part 110, Second Edition, the last of the 10-part treatise, Zelma on Insurance Claims, available from Amazon.com as Kindle books and/or paperbacks. If you found this video to be of interest or useful to you or your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, or my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.